Are we on the record? Okay, thank you. This is in Olivares versus Olivares. Present are Ms. Virga for Mr. Olivares, and Mr. or Ms. Olivares is representing herself in proper person. First of all, I'd ask both of you to raise your right hands, please. She'll swear you.
You and each of you do solemnly swear the testimony that you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes. Thank you.
Okay. First of all, my understanding is that we have reached an agreement in this matter, and I'm going to state the terms and conditions of the agreement. It is very important that you both listen carefully to make sure that I stated it right. I'm not trying to deceive anyone, but I do want you to understand this, my notes are rough, and I need to make sure that we've got it on the record, and once we do that, then I'll have a few questions and we can conclude this matter. First of all, this agreement that we've reached today, and this is for the benefit of the mother, the agreement that we've reached today, you're representing yourself in proper person. And the one question that you've had consistently is whether or not, in spite of this agreement, the agreement can be changed at a future date depending upon the best interests of your children. The applicable law in Nevada, and I'll state it as briefly, but as clearly as I can, is that if there is a showing of changed circumstances relative to the custody and child support issues, that if there is a change of circumstances such that it's in the best interest of the children that the decree be changed, then the court has the authority to change the decree. Just like I told you, as we do it all the time. If issues are resolved, or there's something that happens that we should change custody, or change the visitation schedule, or change the terms of visitation, or change the amount of child support, then we can do so, or the court has the power to do so. Finally, I want you to understand that in doing that, though, this is what controls today, okay? In the future, it could be different. My understanding is that the parties have agreed that the primary physical and legal custody of the two children, and it's Dylan and Dominique, will be awarded to the father, subject to the mother's rights of reasonable visitation, which will be defined as follows: on the first, second, and fourth weekends of the month, and the weekend will be determined by the day that Saturday falls. The children will go with the mother from 1 p.m. until 7 p.m. Additionally, on each Tuesday from 4 p.m. or as soon as they're out of school until 7 p.m., the children will go with the mother. The parties will agree that while the mother will be responsible for visitation, the parties will be expected to cooperate in designating a place to exchange visitation. There will be what we call a 15-minute window, and that means that the mother will be required to arrive within 15 minutes of her pickup time and to drop off the children no later than 15 minutes after her pickup time. But that's to be rigidly enforced so that we make sure the children are picked up and delivered in a timely fashion. Additionally, the visitations for the present will be supervised by a person that's agreeable to the parties. The parties have agreed that the mother's mother, the defendant's mother, is an adequate supervisor. She will be required to be present during the visitations until further order of the court or written agreement of the parties. You two can agree, but it has to be in writing if this restriction is to be removed, and both of you have to sign the writing. Additionally, the parties have agreed that within 30 days of the entry of the decree, that the mother will provide to the father proof that she has undergone a drug assessment and proof that she has entered into a treatment program to address drug issues. as a condition of continuing the visitation. Just for the record, the provisions relative to visitation at Donna's house will be removed. Relative to holiday and special day visitation, the court's standard provisions will control, if there's any dispute about that, the court reserves the right to handle the dispute. But basically, it will be subject to the limitations as to hours and supervision until further order of the court. But the court will adopt those provisions, and what I mean by that is that all the visitation times at the present will be limited to 1 to 7 p.m. And that'll be that.
But we will exclude the 2-week vacation
And
for
we're
now.
excluding the 2-week vacation so that we don't have a 2-week interruption. But other than that, all the holiday periods and stuff like that will simply be, it will have to be, children be delivered back and picked up.
I think that we were gonna put another thing regarding Christmas. I think there's like a 2-week period
Well,
of.
there's an alternating week. Oh, the weekend on Christmas, what I proposed was that on Christmas Eve, let's start with this year. On Christmas Day this year, the mother will have the children from 1 until 7 p.m. On Christmas Eve, the father will retain the children, and then in the following year, on Christmas Eve, the mother will have from 1 until 7, and the father will be able to retain the children on Christmas Day at 7.
So that is the Christmas vacation.
Right.
Okay. We won't be using the standard in the
No,
courts.
not unless by that time the restrictions
Okay.
regarding.
And the same thing with Thanksgiving, because Thanksgiving is usually a 4-day holiday, so we're
right.
going to do it just for Thanksgiving
Right.
Day, correct?
Actually, on Thanksgiving, what I'm going to do is she'll get them every year from 1 until 7. It doesn't make any sense. All right. Relative to the issue of child support, the parties have agreed that the mother will continue to be required to pay the sum of $200 per month as before. Child support. Additionally, the parties will equally divide uncovered health care costs pursuant to the 30-30 rule. The father has agreed to maintain insurance for the benefit of the children. Relative to arrearages, the parties agree that there are arrearages presently owed in the sum of $1,650. That sum will be reduced to a judgment. Relative to the community property and community debts, the only community property consists of a motorcycle. There's a potential buyer who will buy the motorcycle for $2,500. The motorcycle will be sold, and 1/2 of the proceeds will be delivered to the mother upon receipt by the father. Relative to the IRS taxes, for the years of 2012 prior, when the parties were together, they will each remain equally responsible for those taxes. The parties have not yet filed a return. It is unknown what those taxes are, but each party will be responsible for 1/2 of the taxes during those years.
I need clarification. We do know what they owe prior to 2012. That's an estimated $5,000, so we know there is a $5,000
Okay, then they'll
debt.
remain equally divided for those. For
Okay.
the years,
2012.
well, no, excuse me, that's for the years 2011 and back. For the years 2012 forward, when the parties were separated, each will be responsible for his or her own tax liabilities. They have not filed returns for those years, so we don't know what they are. Relative to the exemptions for the years 2012, 2013, the wife will be entitled to take the children as tax exemptions for the years after that, commencing 2014. Those exemptions will belong to the father. The COPE class is to be completed within 30 days by the father. The mother has asked that her former name of Regan, R-E-G-A-N, be restored to her. That, I believe, constitutes the full agreement. Sir, is that your understanding?
Yes.
Okay, are you agreeable with that?
Yes.
Do you believe it's fair and equitable in the best interest of your children?
Yes.
Okay. Okay, Ms. Olivares, do you understand the agreement?
Actually, the arrears. I don't understand the arrears.
The arrears come from the last order of the court until the present month for the amount that you owe for child support. They've contended that you owe $1,650. That'd be about 8 months.
And then you're saying, again, I get the kids on Christmas, it's like going another year. Like,
If it doesn't, this is an order this order, unless it's otherwise changed, will be the order that will control until they're 18, unless it's changed. You have the right to file a motion upon a change of circumstances, changing
I
it.
mean, when you say circumstances, it could be, because you said something about him, unless he's a bad father, or something like that. Or is it when I do everything that I have to do, and
The circumstances, here's what happens.
And they come back to me. I mean.
Basically, what we're saying is the court can look at the circumstances that exist at the time that you file your motion.
Okay.
Okay, they look at the totality of the circumstances. They don't just look at one little tiny fact, for instance, okay? Let me give you a common example, and I don't want to give you too much legal advice here because I'm not your attorney. But let's suppose that Dylan says, I want to live with mom, okay? Dylan's 6. That's a change of circumstance. Is it enough in the totality of all the circumstances to allow him to come and live with you? Maybe, maybe not. Certainly if he's 14 or 15, it's a whole lot more persuasive than if he's 7, okay? But that's just what happens is the court looks at all the circumstances. Basically what they could do is review the situation again to see if since the last decree, since we did this today, if there has been a change of circumstances such that it's in the best interest of the kids that they live with you. Yes, they could. Or they could say no. Those are your 2 choices.
Just feels like,
Well, the only issue is,
Yeah,
and let me ask you the question again, do you agree? I do want you to understand.
It's just a scary thing, like thinking, it feels like and they're getting ripped from me. That's exactly how I feel right now. Like, I feel like I'm getting a raw deal here.
Okay, I can't deal with your feelings, but let me put it to you this way. I
Right.
do want everybody to understand you do have the right to speak to an attorney if you would like. I have agreed to let you do that, but my understanding is that you have agreed. If you have not agreed, you want to speak to an attorney, then you can do that.
Yes. Okay.
No, this is on the record. I mean, this is there. I've tried to be as honest with you as I can.
Right.
I'm just
It's
trying
some
to,
things it's-
you just have to decide, this is your decision. I mean,
I just don't want it to be like this forever, no.
okay.
Because I think the best interest
Well, I
would be
think-
for both parents, for them to be with both parents eventually.
Okay. I don't know how to answer it other than I have.
Yeah.
I can't give you any other choices than I've given you. And I guarantee you the judge isn't going to wait 3 years to go to trial.
Correct. I understand, I'm just saying, I just don't want this, why, for some reason it's going to be permanent.
It's not permanent in a legal sense. There are very few times that we can reserve jurisdiction. What I mean, usually when you have most cases, when the judge makes the first decision, it's over. In issues of child custody, child support, the court always has the right to review it upon a change of circumstances. But it's the totality of the circumstances based on what's best for the children at that time. So we will look at everything, what's best for the kids.
Okay, you know what? I feel more comfortable, yes, I agree.
Okay. Sir, have you understood that?
I do, but I have a request. You said Thanksgiving, you're going to give her every Thanksgiving. Can we alternate? Can she have like every odd year?
You know what I would do is, normally I think Thanksgiving's a meal. If you want to alternate Thanksgiving, that's okay, I don't care. I think it's a fair thing to do. My only concern is usually she's going to have more enough to feed him a meal. It's going to be Thanksgiving. And we did, and I agree. Give her the day, the Friday after Thanksgiving, in the years that she doesn't get Thanksgiving. Same thing for you, would that be okay?
That sounds fair.
That's fine.
Would that be okay with you? Means that you get every other Thanksgiving. But in the year you don't get Thanksgiving, you get Friday after. She
Because they'll be
agrees
out
to
of
that.
school.
And then I
They'll
think-
be out of school, they won't be in school anyway.
They won't be in school.
Day after school.
I think the only clarification we need for the record is she has 30 days to provide this proof.
Right.
If she doesn't, we're giving her a deadline for something, and
Well, it'd be sad. That'd be the whole premise of it. I guess you go back to, I mean, I think the court could then modify the decree based on her failure to do it. I mean, that's what I think. I think you're stuck with modification just like she is.
modify it to what? It's supervised
Donna's
already.
house, I suppose.
Okay, fine.
Sorry.
No problem.
Somebody's not speaking. I mean, I'd like to.
Yeah.
Well, I just want some clarification, because when we give a deadline, we say, well, if it doesn't, then it's subject to him going back to the court and saying for the supervised visits to be at Donna's house. Okay, then that's fine. We put that on the record, and we put that
I
on
mean,
the decree.
no, I think what I'm saying is that it's a condition. It's a condition that we made specifically to grant visitation by
The mother.
grandmother.
Yeah, okay.
And
So
if
this-
he's happy with the grandmother regardless, then that's fine. But if he finds at that point that he's concerned that the grandmother's not an adequate supervisor, then he can go back and change that.
Okay.
I'm not trying to create litigation, but I just think what you do is you look at it reasonably at that point. Maybe this is as severe as he ever wants it. He says, look, regardless of the fact she's not into treatment,
Yeah.
I'm happy that with the children at the grandmother's house, I'm not even going to disturb it.
So can this start when we have proof that she's entered or started?
No.
No, 30
no.
days. I want her to be given access to the children now,
Yeah.
because that's the incentive she has for doing it, in part, is to see that things can
Thank
get
you.
better.
Yeah,
Thank
I
you.
agree.
Don't hold the children as the token because I think, I mean, but here's the point with it, it's a short period of time, 30 days, this is a couple of visits. No. Do we have an agreement or not? I'm just going to simply throw up my hands, either we have an
Yes.
agreement or we don't. Yes,
Yeah,
sir?
I think it's fine.
Yes? Do we have an agreement, ma'am?
Yes.
Yes.
All right. Okay, Mr. Olivares, I'm going to ask you some questions, all right?
Okay.
You realize you're under oath?
Yes.
Clerk sworn you in. State your name, please.
Anthony Olivares,
And what is your address?
3791 Ladina Court, Las Vegas, 89141.
How long have you lived in Las Vegas?
20 years.
Was it your intention when you came here 20 years ago, and is it still your intention to make this your permanent home and residence?
It is, yes.
Okay. Jennifer, there's no dispute that he's a resident of Clark County?
No.
Okay. You stated in your complaint, you filed a complaint in this action?
Yes,
Are all the allegations true and correct?
yes,
You allege in that complaint that you and your wife are incompatible in marriage, is that true?
yes,
Okay, is it true that you have different likes, interests, and interests, that you're unable to live together as husband and wife?
yes.
Any chance of a reconciliation?
No,
Okay. Your children have lived in the state of Nevada during the period of their lives with you?
Yes.
Okay. You've heard the agreement that I've represented on the record today?
yes,
Is that the agreement that you and your wife have made?
yes,
Do you believe it's fair and reasonable?
yes.
Do you believe it's appropriate for your children?
I do,
Do
yes.
you believe it comports with Nevada law?
Yes,
Okay. Jennifer, state your name.
Jennifer Olivares.
Okay. You've heard the question that I asked your husband?
Yes.
Okay. Would your answers be the same?
Yes.
Okay. The court finds, first of all, that it has jurisdiction in this matter, both as to the subject matter and as to the parties. Both are residents of Clark County, Nevada. The mother and both have generally participated in the proceedings. That there is jurisdiction of the children under the Uniform Child Custody Jurisdiction Act. The court additionally finds that the parties are incompatible in marriage and absolute divorce is granted. Upon that basis, the terms and conditions of the agreement as stated here in open court are adopted and made the final order of the court. You're done? That was it. Prepare the decree.
Do I have to, since it was established he's a resident, do I still need to do the affidavit of resident witness, or would that be waived now that it's been established even by
You don't
the
need to do
defendant?
it.
Okay, thanks.
Okay. Prepare the decree and send it to me. I will prepare the decree against the notes to make sure that it says what we said.
And can we take off the record the trial that's set for February 25th?
Yeah, the trial will
I
be
think it is?
vacated. Let's do this. Yeah, no, I'll look at the decree myself, but I have to have it by the end of the week. Can you do that?
This week, yeah, you're pushing me, but I am gonna go do it, then I'm gonna go to the office and do it right now.
Okay.
Where would you like me to drop it off, and what, I could drop it off on Thursday.
Okay, drop it off Thursday to Kelly Houston in Tootin's department.
And which one, Q department?
Yeah, in Tootin.
Oh, Tootin?
Well, Tootin's department.
Which one's Tootin? Department what?
It's D.
D? So can I just put it on the box?
Yeah, but
No,
ask the
Tootin is
reception-
Department D. It used to be my department. It's Department D.
D?
Oh, did she say D?
Yeah.
Yeah, she
Okay,
said
way to go.
D, so
Thank you,
I'm,
Hill.
can I drop the decree in the D?
Yeah, and what I'll do is, and then I'll look at it real quick to make sure that it complies, okay? So you don't have to.
Can I have
sit
the
down and
minutes
review it,
before
and we
that?
don't have to
I'll
go
get
through
them
the
done.
process.
You get them done
We can
today,
get
so
it
I
in
can
about
just,
10 days.
wanna
I
make
get your
sure.
bar
Okay.
number again?
7944.
You guys are done?
Thing is, when, you know, I might
Thank you.
write things
Thank
differently,
you.
and I wanna go
I
straight by
gotta
the
get
minutes.
past this one.
Okay.
You guys
Because
are
then
gonna
if
be
we're not,
next.
he won't sign
Sorry
it.
about
Good luck to you.
Okay, so
I
if you
mean,
get them, I'll
By
print them
tomorrow.
out.
Take care of yourself,
Can you,
okay?
by the end of the day, I'll have them by the end of the day.
Okay, I'll go to and, you know, I'll go to Odyssey and pull them up. Thanks. I will get the decree by Thursday. Okay, that works, all right? Okay. Oh, you know what, let me look through your bill.
What's
I'm
that?
shocked.
What?
Your whole pile was bags,
Oh.
but it's not here.
Okay.
It has to be here, right? Yeah.
That's all right.
No, I'm gonna look for it. It might be on top of my desk, that's all I could think. Because I personally fixed it all, you see, there's all your retainers.
That's all right.
No, I'm gonna look for it. Let me go file this stuff. Okay.
Should we maybe get her address?
Oh, I need her address, yes. I got a mail return from her. I forgot about that. And it was on my mind.
Yeah, give her an address.
Yeah, I need your address because I got mail that was returned.
So it's 3816
3816
Sam
Sand
Joaquin
Walking
Juaquin
Juaqin Q
Quin.
Oh, Joaquin.
Yeah.
Sand Sand Joaquin
Street Avenue. Sorry.
Avenue.
Sand or sand?
San
Oh,
San.
San. Okay.
89102.
To Las Vegas.
Yes.
Okay, so I know where to my stuff at.
Okay,
Thank
there
you.
go. Okay, see you guys later.
Can you help?